James Gribbleman is the Tesler Family Professor of Digital and Information Law at Cornell Tech and Cornell Law School. He studies how laws regulating software affect freedom, wealth, and power. He helps lawyers and technologists understand each other, applying ideas from computer science to problems in law and vice versa. He has a JD from Yale Law School. He studied computer science at Harvard and was a programmer at Microsoft. And today he's going to be sharing with us a paper he co-authored talking about AI generation, copyright, and the generative AI supply chain. James, take it away.
All right, thank you. Let me just set up my slide share, and then I will be ready to get going. There we go. So I'm going to pose today the question, does generative AI infringe copyright? And this, as you mentioned, is based upon work that's in a forthcoming paper with Catherine Lee and A. Feder Cooper. And it's a extremely long look at how generative AI is put together and how copyright doctrine maps onto it. And it's 128 pages. So I'm going to give a very condensed version today. There are a lot of lawsuits against generative AI companies. These are the captions of just some of them. There are others around the world, and there is a lot of litigation ongoing. We've had some preliminary decisions in a few of these lawsuits, but nothing conclusive. And there are lawsuits by book authors, by visual artists, by programmers against Meta, against OpenAI, against Stability. It's a wide range of litigation. They're all getting at the question of whether these generative AI systems infringe copyright. And from the plaintiff's point of view, the answer is obviously yes. And they have a certain obvious sense on their side. If you read the Copyright Act, there is a very literal and very direct sense in which their case is open and shut. So the Copyright Act in the United States, and laws around the world are broadly similar, but I'm going to focus on United States law, tells us that copyright protects original works of authorship fixed in any tangible medium of expression. So that includes books, movies, music, poems, paintings, photographs, all the kinds of things written by the people who are suing generative AI companies. And the fixation requirement, which means there has to be a fixed copy, it's not just something you sing on the sidewalk, is easily satisfied. In order to train on these works at all, they had to have been put in digital form initially. So these are all covered by copyright. And then once you have a copyright in something, you have the exclusive right to make copies of it and to do various other things with that work. You have the exclusive right to reproduce it in copies, which means to make more books, more CDs, more prints, whatever it is. And there are other rights, including the public display and performance, but even as soon as you mention the exclusive right to reproduce the work, it's kind of obvious that generative AI training requires making copies of everything that it's trained on, because the massive data sets that are used to power generative AI training have to make copies. There is no way to train something on a crawl of the web like Common Crawl uses, or to train on the image data sets that are used by Stability AI, or to train on books. There is no way to do that without making copies on some level. So the generative AI supply chain starts from these massive databases of copies of copyrighted works. And that's not all. The process of producing a model from these requires ingesting those works into your cluster that you're using for training. This is Microsoft's data center that's maintaining for OpenAI's training. You have to copy the works out of wherever they're being stored and feed them forward through your network. Doing that involves making at least one new copy as you start. And depending on how you think about what a model is, there may be a copy maintained in the model at the end of the day. You might say, well, you're training on them, but do we know that they can reproduce copyrighted works? Well, the answer is quite obviously yes. If you ask DALL-E or stable AI to generate, some famous works of art by describing them. It is extremely easy to get out recognizable works. Copyright scholar Matthew Sagg had no difficulty getting multiple AIs to produce high quality reproductions of Banksy's Girl with Red Balloon. Now, the details vary a bit. You get some interesting variations on it, but these are all works that we think might be close enough to infringe if they were produced by human artists. The copyright plaintiffs go further, and they point out that AI also threatens the market for them to create works in the future. Andy Baio did this wonderful piece of journalism reporting on communities that produce models specifically tuned to imitate the works of particular artists. Here is a sample of illustrations by Holly Mengert on the left, and on the right you have a series of images produced by an AI fine-tuned on her illustrations. So Holly Mengert sees this as an example of, John Henry competing against the machine, except the machine was literally made from his blood and sweat, that the artists are being used to train their replacements. So to summarize, from the perspective of copyright owners, there are copies of these works everywhere. There are copies in the training data sets and in the outputs. And the model itself, you might say, is a collection of weights. It is just something that's a mathematical representation of works. But that argument doesn't really show that they can't be copies. The pattern of pits on a CD or magnetic representation on a hard drive, all of those are also just patterns of ones and zeros. The point is that you can manipulate a model in a way to reproduce one of the works as the output. A copyright lawyer would say you were doing it with the aid of a machine or device. And from that point of view, these are copies of the works they were trained on. So the plaintiffs would say all of these are infringing. Or, to be more accurate, I should say potentially infringing, because there's another, also quite forceful perspective on whether generative AI infringes copyright. And this is the perspective taken by the tech companies that are producing these models. Their answer is obviously no. They can point to a fairly long string of precedents that show that somewhat analogous systems have been held not to infringe copyright. So this argument starts from another part of the Copyright Act, the fair use provision. And fair use is a famous, perhaps infamous part of United States copyright law. And it says that notwithstanding all of the material about exclusive rights that I've just been talking about, many uses of copyrighted works are fair and permissible and non-infringing. So the fair use of a copyrighted work for purposes such as criticism, comment, news reporting, teaching, scholarship, or research is not an infringement of copyright. And I should point out that I've been relying on fair use already in this presentation. I have shown you half a dozen copyrighted works to illustrate my points. And I certainly hope that I can rely on the fair use exception for criticism, comment, teaching, scholarship, and research. I don't think I'm engaged in news reporting at the moment, but I absolutely rely on this provision. And the United States copyright law specifies that the court has to do an analysis of 4 factors: how it's used, the work it's based on, the amount copied, the effect on the market. I'm not going to go into detail on this here, just to point out that there's a well-developed system. This has been a part of our copyright law for a very long time, and enormous amounts of creative work depend on it. So for a paradigm case of fair use, take this one from a case called Keats versus Scotty Nation. Mayor of a town is unpopular with some of the residents who make a poster featuring his face covered with some text to object to his policy towards block parties. He gets copyright in the photograph and he sues for infringement, and the court throws out the case because this is a fair use. We would say that this is a transformative fair use because it uses whatever expression is in that photograph for a new purpose. It's not to accurately depict who he is. Instead, it's to comment on and criticize him and his policies. It's to make him seem ridiculous and to object. It's been transformed. The expression has been modified in a way that makes it serve a new purpose and create new meanings. So this is a bedrock principle of American fair use law. And AI companies can point to ways in which fair use has been used to uphold the legality of a lot of computer systems that we use all the time. So to start, for example, search engines. If you search for information about Metaculus and generative AI on Google, Google had to make copies of lots of web pages in order to produce its search result. There is no way that it could have known what Metaculus's site says about various topics without sending out its bot to crawl and make a copy of the pages. Indeed, the Common Crawl dataset on which many generative AI systems are based is built in exactly the same way, by crawling the web and making copies. Well, search engines have been sued for this practice, and the courts have uniformly held that web search engines make a fair use of web pages because they're using that input for a different purpose. It's to help you find web pages, not to substitute for the content on them. So there's a germ of an idea in here, which the copyright scholar Matthew Sagg has called non-expressive use, which is that it doesn't entirely count when computers read something rather than humans. The case that most perfectly illustrates this is one that involved the Turnitin plagiarism detector. Some students who were upset that their high school forced them to put their papers through this sued. And while part of their complaint was about the privacy implications of having their work scanned like this, the argument they made that was taken most seriously was the copyright claim, that in order to work, the Turnitin plagiarism detector has to read their essays, it has to make copies of them, and then analyze them. And that initial copy is prima facie an infringement of copyright. The court went through and did a full four-factor fair use analysis, and it held that this was a fair use because it was not for a purpose that competed with anything the students could do. That this was not a case of Turnitin taking their essays and marketing them to the public in a volume of Best Student Writing 2018. This is a case of Turnitin using computers to algorithmically analyze something, not to use its expression to show to people, but to understand whether there are similarities that are suspicious between the paper and sources. That plagiarism detection is a non-expressive purpose. And you can see how this analogy is very appealing to AI companies, that they too are algorithmically analyzing large batches of text, images, and other material to find similarities that would point to important patterns. And that kind of pattern detection, which is at the heart of a lot of machine learning, is, in their view, fair use because it's different in kind from what people do. So if you take that point of view, you could also do something like the Google Books project. You could scan millions of books, including books under copyright, and build a gigantic database of the works. Now, if Google did this and simply put all of the books in copyright on the web for people to read, I think it would be in massive copyright trouble. Publishers have sued projects that did that. They've won lawsuits against a number of these. They have lawsuits pending against other shadow libraries. This is a very strong case for the publishers. But Google didn't give us all the full text of the books. Instead, it made a search engine, like I talked about on the web, and it also created tools like the Ngram viewer, in which you can track the rise and fall of the usage of different terms over time. Again, the Ngram viewer is a kind of statistical processing of a large body of works. So that serves a different purpose than the original works that's trained on. Knowing how copyright has been talked about is different than reading a book on copyright to understand how copyright works. So these principles, you can see how they would be applied to cover the use of models, and you can see how they could be applied to cover the training data sets that models are based on. In order to make the Ngram viewer, you have to build the Google Books database. This principle by itself doesn't cover cases that involve the outputs. So here I think it's helpful to come back to the point that sometimes copying, even verbatim copying, can be a fair use when presented in a different way. This photograph is from a delightful case called Katz versus Scheffel-Dina. The subject of this photograph didn't like the way he was depicted with his tongue out and didn't like the fact that a blogger was using it to make fun of him. So he bought the copyright of the photograph and sued the blogger. And the court said, this is a fair use. That the purpose here is not competing with the market for this photograph. Again, it's making fun of how silly he looks in this moment. And so even copying a complete work, even copying it verbatim, can be fair use under the right circumstances. So consider this page. This is a 2-page spread from a Dorling Kinderly illustrated book on the history of the Grateful Dead. Can you spot the works in there that were alleged to have been infringed? It's the concert posters, one on each of the pages. The Bill Graham Archive, which has a huge collection of Grateful Dead memorabilia, including copyright in a bunch of the works, sued for infringement of the copyright in those posters. And the court said, this is a fair use in context. These timelines illustrating the Dead's career are not competing with the posters. They're smaller, they're not being reproduced in full, they've been changed a little bit, and this added context, putting them in juxtaposition with other works and other material, helps give them a new and different expressive meaning. So based upon that, you can see how the argument would go that the outputs of a generative AI are a kind of transformative fair use. Yes, those images that Matthew Sagg produced draw on Banksy's Girl with Balloon, but they're mixed together with a lot of other material, like a musical mashup or the collage on the pages of the Grateful Dead book. Those outputs have been combined in ways that are transformative. So then pulling back, we look at the training data, and that's a non-expressive fair use. It is a use that, yes, there's a complete copy, but humans aren't using those copies to enjoy them. They're just inputs into the machine. And as long as no human looks at them, that's going to be a non-expressive fair use. And then, of course, the AI companies can make both non-expressive and transformative fair use arguments for the models themselves. They can say, well, on the one hand, this model is this non-expressive, uninterpretable input that does a bunch of AI stuff. And people don't look at the model directly. In fact, we barely know how to understand what's in a model. So that makes it a non-expressive use. And they can also say, it produces this amazing creativity machine. The model is what powers all of the remarkable things that people can do with generative AI. So that makes it transformative. This is a pretty strong argument. But flipping back again, you can see that there are also going to be some limits. Yes, generative AIs can be used to produce new, novel, never before seen images, but you can also use them in many cases to produce things that look enormously like the work of one particular artist or one particular artwork. They have memorized and can repeat back to you the complete contents of a lot of works. So if you'd asked a lot of copyright lawyers and copyright scholars 5 years ago, 10 years ago, about AI, they would have said, yeah, it's mostly fair use across the board because humans don't look at the outputs. If you are using AI to predict customer demand, then you're not using the inputs in a really expressive way. Generative AI, precisely because it can make all of these expressive outputs, really flips the table on that argument. Suddenly, one of the key propositions that it depended on, that people are not looking at the outputs, is just completely untrue. Okay, So perhaps we can stake out a compromise position a little bit in between. Does generative AI infringe copyright? Well, maybe the models and training sets don't, but sometimes users will infringe. How about a system that says users will sometimes create infringing stuff using these tools, and when they do, copyright can come at them. But the generative AI system, that's only a tool. We won't hold the hammer responsible for people who hit somebody with it. And of course, this draws on another tradition in copyright law, the VCR. The Supreme Court in 1984 famously held that Sony was not liable for infringing copies of movies recorded off of TV that some of its users made using its Betamax. The movie studios had sued because sometimes movies would be broadcast on TV. And when they were, sometimes users would hook their Betamax up to the TV and hit the record button and make a home copy for later viewing. Now, the court said that some of these uses were fair uses. If you want to watch Mr. Rogers' Neighborhood a few hours after it aired, well, that's called time shifting, and that's a legal fair use for consumers. But the court assumed that not all of the uses would be fair. There might be some people who use this to make copies and then go sell bootleg copies around to others, that this VCR could be used to make infringing copies. So the court invented the so-called Sony principle, that the seller of a device is not liable for resulting copyright infringement, provided the device has substantial non-infringing uses. So the analogy would go that a generative AI model is like a VCR. It may have some infringing uses, but it will also have obviously substantial non-infringing uses. And therefore, the person who provides that device, the OpenAI or the Google, they're not liable for the infringing uses that some users choose to make of it. It's a dual-use technology, and dual-use technologies have to be legal as long as they have legitimate uses. There's just one big problem with that analogy in the world of generative AI, which is that a lot of models are not provided as finished devices. You don't get the generation device that you use to copy some external source of copyrightable material. Instead, in a sense, the generative AI model already has all of the works it was trained on embedded within it. It's like a VCR that comes with a gigantic library of pre-made tapes. If you buy the copyright owner's argument that the models themselves are infringing copies, this is a VCR that has a huge catalog built in. And the other thing about makes a ChatGPT different than a VCR is it's provided as a service that OpenAI could turn it off at any time. And the fact that it's provided as a service creates more obligations on the part of the service provider to intervene. Napster tried the "we're just a device" defense, and it didn't work out so well for them. The court said, Sony is hands-off. Once they sell a VCR, they can't control how it's used. But you could cut off searches for Madonna at any point. You could cut off users who are providing infringing files in their upload directories. You could cut them off from your directory. And Napster didn't have a great response to that. Once the courts ordered them to try to remove users, they tried and failed and got shut down. Now, this quite rightly terrified a lot of internet companies, and they were concerned about being held liable for all of the infringing material that users uploaded. But Congress had anticipated that conflict. And in the 1990s, it passed something called the Digital Millennium Copyright Act, which created the notice and takedown system that we live in today. So when somebody uploads an infringing copy of Black Panther 2 to YouTube, well, Marvel can send YouTube a notice that says, here's the URL that's a copy of Black Panther 2 at. We are the copyright owner. This use is not authorized. Remove it. And YouTube is immune from liability before it receives such a notice, but is liable if it does receive that notice and doesn't act on it. It creates a safe harbor. So this safe harbor has been the rough compromise that every user-generated content site lives on for the last 2 decades. YouTube uses it, Facebook uses it, X uses it. Everybody relies on this because the expectation is they will take action when they're have infringing stuff brought to their attention, but they're not responsible for taking proactive action. So a lot of people seem to gravitate to the idea that maybe this is the right compromise for generative AI, that copyright owners should point out specific ways in which their works are being output from generative AIs. And then once this is pointed out, the AI companies will have an obligation to act to block this from being used to generate future infringements. But it turns out there are a bunch of practical problems with this seemingly elegant solution. Most obviously, it's not in the Copyright Act. We have this system for user-generated content sites because Section 512 of the DMCA explicitly says this applies to user content hosted for users. There's nothing like this that would apply to generative AI models in the Copyright Act. We would have to rewrite the law to get something like that. But even if we did that, there'd also still be issues. One of them is that it's not obvious how copyright owners could find infringing works. On YouTube, there's a search engine. There's ways to go and look through it to find those copies of Black Panther 2. How on earth can a copyright owner monitor the way that every user uses a generative AI model? It's an incredibly hard task that would both involve massive invasion of users' privacy and an incredibly ill-posed problem, because that service could produce infringing outputs even if the user didn't use the specific keywords the copyright owner is looking for. So it's a hard monitoring problem. But things aren't any easier for the AI companies either. If you've got this list of specific outputs, we do not have general purpose technology that can take a model as complicated as the cutting edge text and image models and precisely surgically filter out content. When you have a hosting site, it's really easy. You just disable that particular link. You block access to one thing in the database. It's precisely the complexity, the generativity of AI systems that mean we don't know where in the model knowledge of a particular artistic style is located. That's not even well defined. It's distributed throughout the network. It's an active area of computer science research to find this. You can't just retrain the model without that work in it trivially. Model training is slow and expensive. So this is a system that's not authorized in law. It's too hard on the copyright owners. It's too hard on the tech companies. Not clear that this is the right solution either. So we've been through 3 solutions so far. Obviously infringing, obviously not infringing, notice and takedown compromise. None of them provide a clear answer to when copyright liability attaches. And I think we should stop looking for one. We are not going to get a simple, clear, across-the-board answer that resolves all generative AI cases. We have to do what lawyers are always telling to do, and you're going to groan when I say this, but we have to embrace the complexity. It depends. The heart of copyright has always been the question of when 2 works are so similar that one of them is usurping the aesthetic value of the other. That's deeply subjective. It depends upon everything humans know about aesthetics. It depends upon lots of stuff that's in here and in lots of people's brains. Does the stained glass image on the right copy too much from the photograph on the left? This involves requiring us to play art critic. We have to describe the scenes. We have to notice how they are similar and different. We have to recognize that the costume and the pose are traditional and Hawaiian, but the particular angle might have been created by the photographer. You have to go through all of those elements to decide whether these works are too similar or not. And I will say that in this particular case, the court said that no, they're not. The stained glass artist copied only the idea. But even once we know that 2 works are similar, we still have to do that fair use inquiry. we have to ask whether the copying is justifiable. Once you put Shepard Fairey's Obama Hope poster up next to the Manny Garcia photograph it was based on, it's obvious that one was based on the other. Fairey used it as a model, as he eventually conceded in litigation. That doesn't make it illegal. One could still say that the message embodied in the Hope poster is transformative enough that it should still be legal. That's not just an artistic question about how similar they are. It's a policy question about how much freedom we want to allow downstream users to remix and rework things from the past. So the point is, this is always going to be retail level, work by work, individual image by individual image. And this is going to be the same, it's going to be exactly the same for generative AI. We know that generative AIs often memorize nearly exactly some works in their training data. This is a famous example showing how image models can memorize specific works and the names they're tagged with. But even finding exact matches is going to be not enough. We're going to have to engage with very hard questions in copyright law and theory. So here's an example my co-authors and I came up with while working on the paper. If you ask Midjourney to produce images of an adventurous archaeologist, you get images that look like this. And yes, there are obviously a bunch of archaeology tropes in them. The one on the upper left, for example, seems to have some ancient ruins in the background. But when you start looking closer, you're like, okay, wait, that jacket, the hat, the whip, the shoulder strap, these are drawing on the specifics of representation of Indiana Jones in the Indiana Jones movies. There are things here that are not common to all archaeologists. So you might say, is it infringing on the movies? Well, that's actually a really hard question because arguably the movies have made adventurous archaeologist into a trope, the kind of thing you would find on TV tropes that is now part of the common cultural heritage that anyone can use. There is no way for us to automate that line of knowing what's a common cultural trope versus what is specific to the representation of a particular character or a particular movie. That is the hard work that copyright has always required of judges and juries, and that hard work is not going to go away. Here's another example. This harkens back to the Holly Mengert example of similar illustrations that I gave much earlier. You can get image AIs to generate work in the style of particular artists. In fact, you can use particular authors too. You can pretty easily get them to write rhyming poetry in the style of Dr. Seuss, for example. These photographs, I should say, don't resemble any specific Dorothea Lange photographs. They're in some sense based upon her entire corpus of work, but they are capturing something very recognizable from her. Should we count that? Should we not? This is a hard question in copyright theory and policy. And again, there's no way to wrestle with it without getting into specific photographs. You can't debate this without having in front of you lots of examples and trying to classify them into the okay and not okay. This is similarity in expression. Here's another example of places which we have to embrace complexity. Complexity of use. This is from a Supreme Court case decided this spring called Andy Warhol Foundation versus Goldsmith. The photographer Lynn Goldsmith took a photograph of Prince in the 1980s. Andy Warhol was commissioned to make a print of it for a magazine feature. And then after Prince's death, the magazine got back in touch with the Warhol estate to license the print again, and discovered that Warhol had actually made 20 prints. They licensed one from him called Orange Prince and ran it. And then Goldsmith realized it was based upon her photograph and sued. And the Supreme Court held that this was not a fair use because it was competing with her photograph in the market for licensing images of Prince. But the court was extremely careful not to say that Andy Warhol infringed when he made the original print. It's a much harder question. Because the point the court was getting at is that fair use is use by use, and making a single fine art print may be different than using that print on a magazine cover. Which means, I should say, that using that generative AI output to show to your kid for fun versus putting it in slides for a presentation versus putting it on a magazine cover, those three cases might be different uses. And there's nothing in copyright law saying they all have to be illegal or all have to be infringing. They could get different treatment. And that means we have to be paying attention to the specifics of the use as well as the specifics of the output. But there's even more. This is the image of the generative AI supply chain from our paper. And our point is that it starts from content, which is put into databases, which is then collected and used for pre-training models, which are then fine-tuned for specific applications, that are then deployed in complex systems, and then you feed back into the earlier stages based upon the results of the later ones in order to make your model better. And only at the end of this, you get your cute cat picture out, which means there's a huge amount of diversity in this supply chain. Any given data set or app could draw on multiple sources upstream. We trained our AI model on this database and this database, but it could also be fed into lots of different outputs downstream that people have used Facebook's Llama model for all kinds of things now because it was released as weights. There are all kinds of apps built on OpenAI's APIs. And beyond that, every stage could be done in public or behind closed doors. It could be released under proprietary licenses or openly. Different people could do different steps. Again, those different stages could require different copyright treatment. So to give just one example, if you want to contrast the open Llama 2 model with Google's Bard tool, one of them is a product released for anyone to use, the other is a service. If you think back to the Sony Napster distinction, there's no guarantee that the two of these would be treated the same way by copyright. Maybe Llama is better off because it has more downstream uses and it's no longer controlled by Facebook. Or maybe the fact that Facebook released it makes Facebook worse off because Google can turn off the tool anytime it needs to make changes to comply with copyright. Different business models, different technical models are going to have different consequences. Similarly, different people could have different responsibility for infringing outputs. Suppose that I go to an image model and I type in Anna and Elsa. I am looking in some sense for an infringing image. It seems like I'm the person who ought to be responsible if the result comes back looking like everybody's two favorite Disney princesses. If I type in Ice Princess and I get back a picture of the two of them, maybe that's on the image model, not on me. I would have been happy with any kind of princess picture for my kids, but no, it's the model that sent an infringing one to me. Or maybe I say, watch Frozen 2 to a video model, and this whole thing is about piracy, and the model maker and I are both in on it. Again, a copyright system that's not even capable of making these distinctions is not going to do a great job. So let's zoom out to the big picture about where this leaves us for the future of copyright. The obvious choice is between strong copyright. The copyright owners win these lawsuits and AI models have to get licenses, versus weak copyright. It's fair use to make models. You can do what you want with them. But actually, each of these has two futures embedded in them. If we have strong copyright, maybe this means everything is trained on licensed data from big publishers and media companies. They get some money, they share it with their authors or not. And it's basically big copyright is holding the high cards here. But maybe if it's illegal to train without authors' permission, the databases that big copyright has the rights to are just too small. Maybe you can't do anything useful with just what's in the Penguin Random House catalog. You actually need the whole web to get a great model. I call that world the anti-commons because you need to get licenses from millions, copyright owners, billions of them. There's no way you're going to get all of those permissions, and it winds up permanently damaging the quality of models we have. On the other hand, suppose the companies win, and these are held to be fair uses. I mean, one obvious future is this means that it is full steam ahead for OpenAI and Google and Meta, and the big players in this space get powerful models that they can do whatever they want with. Then again, maybe it's a current technical blip of where we are in the difficulty of model training and the quality of algorithms. And you go down the road a few years, and anybody with consumer grade hardware and a little bit of money for storage can train a perfectly fine model that's good enough, at which point the OpenAI has no moat and neither do we comes true. And basically everybody has these tools in their pocket trained on everything. These depend upon economic questions and technical ones, not just legal ones. Or we might get something sort of in between. We sort of muddle through. This is the world we're in right now. The companies are starting to offer copyright defense pledges to their customers, saying, if you get sued, we'll defend you. They'll take all the risk on themselves. Maybe the courts will distinguish legitimate big companies that seem to be trying to do things right, maybe who are just using AI as a cover for building pirate databases. Maybe there are big societal problems here that we shouldn't try to settle with copyright. The question about the future of human labor in a machine age is kind of a big question for a system designed to deal with authors' rights to deal with. Maybe copyright is a hammer and not everything is a nail. So I want to finish with a broader observation, which is I've been talking about copyright infringement, but that's only one side of the coin. There's also the authorship problem. This is seen most obviously in cases like Zarya of the Dawn, where the creator of a comic book who used Midjourney to make the illustrations tried to register copyright. And the Copyright Office said, no, you can't get a copyright in this because they were created by a non-human author. Copyright only protects works created by humans. Well, this is going to be a big policy challenge for the coming years. And this is going to have as much of an effect on the future of AI and creativity as the infringement questions. Right now, we have an immense body of human-created work that's being fed into machines. Well, we're going to soon have a situation which is an immense body of machine-created work, and how that interacts with people and how the law applies to it is an equally big question. It is not obvious that the copyright system we have right now, not just in its details, but it's in broad strokes, is the one that we need. The last time we had a technology that was this big a deal was the printing press. That was the most fundamental transformation in how human creativity could be reproduced and spread. It changed us from a world where individual patrons sponsored authors to give them the time they needed to write, create, to a world in which people could be paid by selling copies. And a world where they could be paid by selling copies was one that needs copyright to prevent other people from coming in and undercutting the market. Well, we're now in a world in which generative AI may drive the cost, not just of reproducing, but creating down really low. And that throws the fundamental assumptions of a copyright system, that creation is expensive, but distribution is cheap, into really sharp relief. Maybe we need a system that is as different from copyright as copyright was from patronage. I don't know. I want to pose that question and also to answer yours. Thank you. I'm going to turn to the Q&A now.
Yes, thank you, James. That was fascinating. And that's an incredibly provocative question to end on. I have a few questions here in the Q&A that I want to pose to you now. One here, super fascinating talk and examples. A common way I've seen people get around takedown flagging in videos is by making small-ish edits, chopping out parts of the video, changing the playback speed, etc. How does copyright law treat modifications of this type? And are there any parallels to how generative AI can produce something similar, but with modifications from the original work?
That is a great question, both for the copyright part of it, and also because it opens up some really deep issues that connect to generative AI. So the copyright part of it is that small variations like cutting out parts or rearranging the order of clips from an episode or flipping something left to right and speeding up the video, those things don't keep it from being infringement. That small changes like that don't really affect infringement. If you made bigger changes, you radically recut something. If you put it with different music, you could eventually wind up with a transformative output. But the small things don't do that. What the small things are doing is evading automated filters. The point is not to convince a court that you made a fair use if you get sued. It's to avoid getting noticed so you never get sued or get the takedown in the first place. And so what this shows you is that copyright on the ground is implemented algorithmically. Copyright owners are depending upon Content ID and similar systems to find their works and identify them. And so if you think about the kinds of filtering or detection for copyright issues that AI companies can do, it's going to be in the same general class of techniques that we're using right now to find human-made attempts to evade copyright. They're going to look for informational similarities in works. They're going to do various kinds of transforms to see how close they are in different spaces. There's going to be a convergence between those and the techniques we're using to filter AI models. And you can filter AI models by blocking certain keywords in the generation. And these are some of the guardrails that companies are adding right now to look at user prompts to see if they're asking for work by a living artist, for example. Then they'll have other techniques that involve training the model in certain ways. And this is going to be a huge area of research. I think what your question really shows is that the practical reach of copyright on the ground in these systems is going to be deeply dependent upon the state of the art in machine learning algorithms.
We have some, that's a great answer. Again, very thought-provoking. We have some more questions here. How might a new copyright law redefine what a machine is? Because now it's related to machine reproduction. This dates back to piano players, I think. But with AI, this is machine creativity, maybe? So more of an open-ended question.
Another great question is the player piano is an incredible example of how copyright law thinks about machines. When the player piano first came around, the Supreme Court literally held that a player piano roll wasn't a copy of sheet music because you couldn't look at it and understand it. There's this deep sense that copyright is for people and this roll was for a machine. That was in 1908. The very next year, Congress overrode that decision and said that no, the player piano rolls are part of the copyright system. You need to pay a royalty to make piano rolls of an existing song. But at the same time, Congress changed the rules around them. You didn't have to negotiate permission. You could just pay a set mechanical royalty. And that royalty is still with us. It's not mechanical anymore. We don't have player pianos. We don't have record presses. I guess we do still have vinyl presses, but most music that we pay these license fees for cover versions is sold as digital downloads or streamed now. That's just it still survives from that day. I think those ideas are still with us. And one of the things that example shows you is that our societal and copyright notions of what a machine even is change rapidly as people get used to it. I think the copyright questions, all the legal questions, are going to look very different even 5 years from now as these get integrated into people's daily lives. How, I can't predict, but I think we're going to get comfortable with them, and some answers will seem obvious that didn't seem so now.
Another question here. What's your impression of how easy or common it is for AI to output copyright infringing material by accident? Is it pretty rare to get outputs that could potentially infringe copyright if you aren't putting in prompts that are very similar to existing material?
This is a hard empirical question because it depends so much on the behavior of people using AI in all kinds of ways, and those interactions are really hard to monitor. My sense overall is that this is fairly rare, that people typically tend not to get back things that are really close to somebody's a specific piece of work if they weren't looking for it. But I have to admit that's completely anecdotal. I don't have evidence to back that up.
You mentioned earlier an AI generated piece of art and how it could not be copyrighted. And I wonder, is there even a mechanism for determining whether a given image is AI generated? So if the artist had just claimed this was not AI generated, is there even a way to verify that? Is there a mechanism for that? Would courts even try to verify that?
So the short answer is no, that AI companies have been trying to develop either techniques for detecting AI generated work or ways to embed watermarks in AI generations such that they can be reliably detected and can't easily be removed. And so far, there's not a great way to do that systematically. There are folk understandings like AI isn't good at hands. Like, so you look at the hands to see the 6 fingers, or you look for certain, Midjourney has a telltale glow. But those are very much artifacts of particular AIs, particular training, particular state of the art. We don't have, as far as I know, good general purpose AI generation detection or watermarking.
Yeah, and it truly does seem like there will always be some technique by which one could reproduce much or most of a given AI generated image such that it would be impossible to tell whether it was human generated or AI generated. And it seems like humans, or I expect, and I'd be interested to hear your expectation, whether, yes, you will always be able to make the claim that a given image is human generated. And so it's unclear how copyright could fail to be extended. If someone has enough ingenuity, if they're motivated enough, they'll be able to make the plausible claim that an image is generated by a human.
I don't know that's true in general. I think I would say instead that our techniques aren't general, but there are often valid techniques that work for specific kinds of images and specific AIs. So it's quite possible that at the time an image is generated, nobody can prove that it was AI generated. But 6 months later, we have a good statistical technique that can look back and say, oh yeah, of this class of stuff, yeah, these are all outputs from this AI, and it just telltale once you know this pattern of how it produced things. But you're not guaranteed to have that. And again, I am speculating here on the basis of trying to summarize from the examples that I've seen.